Calmay and Brian, who are presenting on crossover issues between child support and juvenile dependency. Both are former ladles, so they know what we do, they know what we're working on, so they're going to present for us some valuable information on how we can better advise our clients who always are asking child support issue questions, and usually we don't have the greatest answers to them. So hopefully after today's training we'll have a better understanding of how to better advise those clients. So, Brian and Calmay.
Thank you so much, Jackie. Okay, so I'm Calmay Pham. Thank you so much for inviting us here today. We are going to go over child support law in general and tell you more about our agency, what we do, what we don't do, and how dependency cases affect child support.
Yeah.
So, you are going to get a lot of information today, both in our slides and during our presentation, more than you'll ever need. But hey, this is an MCLE. The most important takeaway is that if your clients ever have questions about establishing child support or how to respond to a child support action, they should contact us. So you've been provided with a handout with the information for our 6 offices and our general customer service line. Your clients can walk into any office or call that line for information. Literally, the most important takeaway is direct them to us and we'll take care of the rest. Okay? Finally, please just write down any questions that may come to you during the presentation. We are going over a lot of information, and we may actually get to your answer later in the presentation. We'll answer any questions we missed at the end. Thank you.
Thanks, everyone. Like Calmay said, my name's Brian, and it is really nice being back, seeing some old friends and familiar faces. As she mentioned too, we do have a lot of information, and we'll try to go through it as fast as possible. And we're going to start with the big picture and kind of begin with where the child support services started and the history of child support. Yes, there is a history of child support, and go from there. Just to give context to how much child support affects everyday lives, a national study done in March of 2017 showed that 28% of American children live with one parent while the other parent resides out of the home. 81.7% of custodial parents are the mother. And a surprising fact is that 31.8% of those custodial parents live below the poverty line. Nationally, on a yearly basis, $37.9 billion is collected or due for child support, and only 62.3% of that amount is actually received by the custodial parent. So there is a giant need for services to help enforce those orders. More locally, in LA County alone, our department serves over 250,000 cases, and we collect roughly $1 billion in support each year. So, or $500 million in support each year. As I said, there is a history to child support. We'll keep it brief because it is kind of boring, but child support began during the New Deal and the Depression, the post-Depression era in the 1930s, with the Social Security Act. And that was aimed to provide stability to dependent children and families. It wasn't until almost half a century later, in the 1970s, that child support was actually addressed by the Social Security Act amendment. And at that time, the federal government mandated states to establish departments to enforce and create and enforce child support orders. It wasn't until about 5 years after that that foster care services came into play, and that's what you guys deal with, and that came in Title 4E. Throughout this presentation, you'll hear Calmay and I reference Title 4D. Again, that's where, when the child support department's involved, it will come from, our authority comes from the Social Security Act Title 4D, and that's what the courts are carved out from. And over the years, there's obviously been legislation that, that further provides enforcement mechanisms for child support. In the 1980s, they mandated that the government can ask the courts to order withholding orders from people's wages. So that means if there is an employee who is paying support, we can just garnish it from their wages. Likewise, over the years, they created what's called the Paternity Opportunity Program to establish paternity, and that's at the hospitals. A father can acknowledge paternity voluntarily by signing that. There's pros and cons to that. That's a big issue in our courts, but that's what they established. Welfare is a big aspect of child support. When a parent receives welfare for the children, that will trigger a child support case. We are required to seek reimbursement from a parent that's not residing in the home if the home is receiving welfare. And in California, that's usually through the CalWorks program. Lastly, and we've had a conversation already a couple times this afternoon with people on who we actually are. In the past, child support was the district attorney, and for many years that's what it was until, in Los Angeles in particular, a series of news articles came out essentially critiquing the whole child support process and how punitive a process it was and ineffective. So in the late 90s, the legislature decided to carve out the child support as being its own departments throughout the state. And we are not county council. We are not DAs. We're a hybrid of both because we perform both civil and criminal actions. However, we're child support. It's specifically that, so the attorneys are for that. Throughout the nation and in LA County, the organizational structure is based on the Social Security Act, as we mentioned. And at the federal level, the Office of Child Support Enforcement oversees the state levels, DCSS, or the California Department of Child Support Services, which at the local level oversees us. And so we're known as a local child support agency. And in LA County, it's called CSSD, the Child Support Services Department. In other counties, it might be a little different. They might go as LCSAs or DCSS as well. For CSSD in particular, and this would be in your first handout, I believe it's on the back page, child support is organized into 6 divisional offices. And we provided this so that you guys can give to your clients if they do have questions, or you can refer them to this. But basically, child support is supervised under the County Board of Supervisors. It is one of the departments of the county. We are headquartered in Commerce, but we have 6 regional offices, starting with Van Nuys, Commerce, Pomona, South LA, Torrance, and Antelope Valley, or the Lancaster area. In the past, the regional offices did service cases for where a participant might live. That's changed over the years. Our structure is now based on a certain function or procedure of the child support case. For example, in Commerce, that's where cases start. So any case that is established through us will start in Commerce and then be filtered out to a different enforcement division. Commerce also does interstate cases if parents or one parent might live out of state, or internationally. There's an international division. I work in the South LA office, which is an enforcement division. Calmay is in Commerce, where it's establishment. And one thing we want to make clear is your clients, if they do need to contact us, can go into any of those offices. Someone will help them. Their case might be managed by one of the regional offices, but they're welcome to come in at any of them, and someone will assist them with that. An important note is that we do not represent what we call the participants or customers. It's gone to a customer-based model. They are not our clients. We represent the public interest, and that's to make sure children are being taken care of based on the parents' abilities and court orders. And we are separate parties in any legal action. When we do go to court, all of our cases are heard at the Central Civil West Courthouse, and that is located at 600 South Commonwealth, which is near Southwestern Law School if you went there, or Koreatown. Again, our courts are considered Title 40 courts because when the government's involved, the court gets its authority from that legislation. And surprisingly, it's only commissioners, it's not judges. So the commissioners sit in 4 courtrooms, departments 2, E, F, G, and H. And unlike in Dependency Court, where there's a lot of papering going on between courtrooms, our courts, it's very rare that that will happen. Participants or the county will make what's called 4251C objection before the hearing. That just objects to the commissioner hearing the case. They will still hear the case, and then it goes to the judge to review. Some important information for your clients is they can appear telephonically at these hearings. They just need court approval for that. There is a family law form that they can request that. That's the FL 679. Participants are not appointed counsel like in dependency court. They can appear in pro per by themselves, or they can hire their own counsel. Again, we do not represent them. We are a neutral third party. Currently, the policy is for the commissioners only to hear child support and monetary issues. They don't hear things like custody and visitation and spousal support. We do enforce spousal support if child support's attached to that. We won't just do spousal support. But these commissioners don't modify support or custody, spousal support or custody orders, which is good for us because we can just tell them go to the branch courts and handle it, the private courts. An important note also for your clients is the family law facilitator. As we said, we don't represent them. They can represent themselves, but they obviously need help filling out forms. They don't know the forms, they don't understand it. So there is a family law facilitator located at CCW on the 16th floor, and there's a phone number provided there too. We highly suggest using that family law facilitator because they're aware of the court system where we are. There are family law facilitators throughout the county, but this one's the best one in terms of pointing your clients in the right direction. So part two, we'll talk about support obligations and calculating child support. Where to start? When does a support obligation actually kick in? Well, that's basically when parents have children. Under California law, both parents have an equal responsibility for their child. In terms of when dependency kicks in, a support obligation will still exist if the parents lose custody and control of their children. It won't automatically pause or terminate if a case opens with your court. Another issue is legal guardianship. Support obligations exist if the legal guardianship is a court-appointed legal guardianship, such as through your courts. The distinction for the courts, there's a lot of history to this part, but basically they look at whether the guardianship was voluntary or involuntary. If a grandparent voluntarily takes custody outside of the dependency system or court appointment, then they're not really entitled to support. But if the grandparent becomes the legal guardian under dependency, then yes, they can ask for services and they're entitled to support. Last point is that support isn't going to be automatically terminated, as I mentioned, when the dependency case kicks in. It runs until the child becomes an adult, essentially, or by court order. And that's what we'll talk about, the duration of support. Child support runs basically until or in general, until the child is 18, unless they're still in high school, then it's through their high school graduation date, or until they become 19, whatever comes first. That's the standard. The termination of parental rights is one of the reasons why support might end before that. So it doesn't really need a court order. It probably should go to court to clear it up, but once a 2-6 hearing happens and a court does terminate those parental rights, they no longer have that obligation. Important to note, and you might need to make this clear sometimes to clients if they ask, any back pay they might owe up until that point will still be there. It doesn't get extinguished. So they still owe that child support for any back dues. And interestingly, the death of a parent doesn't extinguish child support automatically. They have to go to court to that. It might trigger a change in support, but because of insurance programs and so forth, support obligations can still run. How child support is calculated in California. Each state has its own method. California uses what's called the Guideline Formula. And it's a uniform guideline throughout the state that is really a complex algebraic formula based on the parents' incomes and their custodial time with the children or child. That's the formula up there, that C equals K something something. I didn't even know how to really say it aloud. But basically, it's child support is CS, K is the amount of both parents' income, HN is the higher earner's net monthly disposable income, H percentage is the approximate time of custodial time for the higher earner, and TN is the total net disposable income of both parents. Okay, so the statute is virtually, it beckons the eyes to glaze over. And that isn't my quote, that's actually the appellate court's quote. There's a great case called In Re the Marriage of Hall, which the appellate court essentially bashed this whole system and did calculating support, which is kind of fun to read when that's your area that you work in, to hear the appellate court really bash it. But they said that the actual text of the section would probably not be called the legislature's most lucid work by anyone. And in describing child support to our participants, we try to make it and explain it so that's a fair and accurate process as possible. And the appellate court said it's hard to do that when, quote, the aura of occult wizardry surrounds this formula. So it's not something that's really easy to use, but the legislature came up with the method utilizing what they call the principles of child support. As we talked about, is he okay?
Okay.
Your first primary responsibility, if you're a parent, is your child. So that's the first principle. And as we mentioned, each parents have a mutual responsibility for support. Support will be based on the parent's income and or their ability to earn. And it takes into account the interests of the children, which is to share in the standard of living of both parents. What's calculated in the support formula is presumed to be correct under the law. However, and this is the reason why we go to court most of the times, it can be rebutted. But it will be the person that's trying to rebut the calculation's outcome to prove that the support order should deviate from what it says. The formula looks like this, and this is available on the public website for DCSS. We use a enforcement calculator at the courts, but it shows both sides. Each parent will have one side that goes down for the factors that go into calculating support. And these guideline factors are really to determine the income. We do this process very similar to preparing taxes. We start with gross income of both parties. We ask them these questions. These questions relating to their wages, their health insurance premiums, union dues, and so forth, are the only factors that go into the calculator. There might be other factors. For instance, there might be a parent's rent. That does not go into the calculator. Only these factors. And in particular, I'd like to point out that the percentage of actual custody and visitation. The key word is actual. Sometimes parents come in and say they have 50-50 or 40-60, and that's not really happening. We, in the courts, use what's actually happening. And so that's what the calculator will generally look like, and again, it'll generate a number for what's owed in child support each month. Lastly, for this section is foster care cases and relating to you. In terms of calculating support, again, a parent is obligated to pay support for a child during foster care if the child's placed in foster care. And if the parties reside together, then we'll calculate support combining their incomes, and then the foster care parent or the caretaker will be zero on the other side. If they reside apart, then they'll have two cases against each parent, and it'll just be like any other case where they're calculated separately. And with that, I'll pass it on to Calmay.
All right. So, okay, now we're going to move on to a case study. So Brian just went over the principles that govern generally how child support is calculated. And let's look at an example. Let's look at the example of Britney Spears and Kevin Federline. So this whirlwind romance that gave us the reality show Britney and Kevin Chaotic ended in divorce. No one remembers that? I watched it. Okay. So this relationship ended in divorce in 2007. Britney was ordered to pay $20,000 to KFED in child support, $10,000 for each child, and that order actually remained in place for a very long time. Kevin Federline, I'm just going to keep calling him KFED, filed to modify child support in 2018, claiming that the current order was not enough to meet the reasonable needs of his children. So, I mean, part of his argument was that he said he only earns $3,000 a month because he's too old to dance, and he isn't making much money from rapping and DJing, and he was asking for a child support increase to $40,000 a month. Now, actually, the question, we did go over the guideline, but the question was not income ability, or what a parent is able to afford under the guideline, or what's reasonable under the guideline, because Britney is a high wage earner. That's a special category where basically it doesn't make any sense to put in the $137 million she made from Vegas, her Vegas tour, into the guideline. So child support can be anything. Then the argument moves to what is covering the reasonable needs of the children. KFED also has a wife and 4 other children, so obviously Britney's argument was that he's asking for the extra money to support his lifestyle, not the children that they share. However, a controlling principle that kind of, this case did resolve, and I believe the controlling principle that ended up kind of determining the outcome was the concept of the standard of living should be equal for both households. So if the children are enjoying a certain lifestyle while they're living with Britney, then Britney's money actually should follow the children so that they can enjoy a comparable lifestyle with KFED. So they ended up settling, and the amount is under seal, so I tried to look it up. Didn't work, but it did say that it was thousands more, which is probably appropriate because the last order was from 10 years ago anyway. Okay, so now that Brian has gone over child support generally, I'm going to go into more detail about our agency. So again, we are a separate county agency, and what we do and how we operate. Okay, so there's 4 main types of cases handled by Child Support Services. The first kind and the broadest kind is welfare cases. So this is actually the type of case that we originally, or the kind of child support statutory and legislative scheme opened to deal with these kinds of cases. So more specifically, a welfare case is a case where a child is receiving cash assistance, so CalWORKS, welfare, those are other words you'll hear for it, from the Department of Public Social Services, DPSS, and the non-custodial party is not reported in the home with the child. So some families, they do need cash assistance, and if they're together and they ask for cash assistance, that's fine. That will not trigger a child support case. It's only where there is a non-custodial party being reported out of the home. Now, when a custodial party or parent signs up for cash assistance, they assign their right to receive child support to the county, and we are required to seek reimbursement under Welfare and Institutions Code 11477. So a custodial parent cannot receive both cash assistance and child support, even though the reality is probably that they need both. But yeah, unfortunately, they are not able to get both. They get the cash assistance, and then we collect child support as reimbursement for the money that has gone out. Okay, these cases are initiated when DPSS sends us a service request, or an SR, to initiate the case. These cases are non-voluntary and will remain open so long as a child is cash aided. So a lot of times, and this is a common problem, people will sign up for cash assistance and they don't actually know what the consequences of that is. So they think, great, I'm getting food stamps and health care and cash assistance, wonderful. And it's not explained to them that that means there will be a child support case that will be opened against the other parent. And so they say, never mind, I don't want child support from that person. Well, they don't actually have that right because it's already been assigned to the county. Okay, and other forms of assistance such as CalFresh, so food stamps, and Medi-Cal actually don't trigger a child support case. So we're just talking about cash assistance. The second kind of case that we have are non-welfare cases. So these are cases where a custodial party, or sometimes even a non-custodial party, just comes to us and makes an application for services. So I do have a link here. It's probably the easiest place to send people. The website has a list of all the different ways they can apply, or they can just apply directly online. And the benefit of this is by pulling us into the case, we provide certain services, including locating a non-custodial parent, verifying income and employment. We provide genetic testing for free. We establish parentage if it hasn't been established. We obviously establish a child support order and then enforce that order. And we also enforce spousal support as well if it's concurrent with a child support order. And these kinds of cases, they are voluntary and they can be closed at any time. So at any point they can say, you know what, we can handle it ourselves, why don't you guys step out. So foster care cases is our third category. Obviously, this is what is most relevant to us here today. It's very similar to a welfare case. Basically, cash assistance is being provided to support a child who is placed out of a particular parent's care. Obviously, that includes kin gap cases. It works the same way. Our agency receives a service request not from DPSS, but DCFS. And the way it's supposed to work is that the SR is made after family reunification services have been terminated, because obviously the idea is to, if there's a chance that the children might return to the home, you don't want to be taking money out of that home. However, I say that that's how it's supposed to work because sometimes I've heard that there are relatives who aren't receiving foster care assistance, and so they will be told just go sign up through the regular welfare process. And if they do that, that will again trigger a case coming from the regular kind of welfare route. And a separate child support case is open for each parent for these foster care cases. And the final category, it's not necessarily its own category, it's kind of, there are cases where child support has already been established through another family law proceeding, parentage, dissolution, restraining orders. So we can take those orders that were made by another court and enforce them. How we would do that is we file an FL 632, a notice regarding payment of support, notifying the court and all parties that instead of maybe paying that other parent, you would pay the county, and then we keep the accounting and handle all necessary enforcement. And again, these cases, the parties may be aided or non-aided. They might have signed up for cash assistance, and then we opened a case and found out they already had an existing child support order. And again, spousal support, usually we find them in these kinds of cases where maybe they had a dissolution and it's already in there. Okay, so I prepared this chart for you. You can refer to it whenever you want. I'm just going to go over it real quick. Essentially, this is kind of a very basic path for how we handle cases. So case initiation. We get a case either, again, a service request from a public agency or an application for services from a non-aided individual. We determine whether there's an existing order. If there is, great, we'll just take over enforcement. If not, we will file our own summons and complaint, serve the other parent, offer genetic testing if parentage has not been established, and then we meet and confer with all parties to try to reach a stipulation. So again, a difference between how things were in the 2000s when it was coming out of a DA agency is we've moved to a customer-oriented model. The kind of philosophy is early intervention, pull the parties in, try to work through to get an order that will make someone feel like they were part of the process, and also encourage them to continue paying, because getting these really high punitive orders left us in a situation where people felt kind of just abused by the system, and they never end up paying, so we just had all these arrears. Okay, so if we can't reach a stipulation, we will go to a contested hearing. And again, the county does not represent either parties at the contested hearing, but we do advocate for what is appropriate under the law. And after we get the order, we proceed to enforcement, and any orders made can be modified by the court at any time upon a showing of a material change in circumstances by the moving party. Okay, so why a CSSD case? So as I mentioned again, child support orders can be made through any other family law proceeding, and it's not necessary to have us be a party. However, we do have kind of a lot of other bells and whistles that might make it worth it to somebody. So first is we don't require, our cases don't require any filing fees, so nobody is paying for a petition or an answer or any fees at all, okay? We have many more resources available to locate and serve a known custodial party. We can access DMV records, other kinds of public records. We can get information from the post office. We can find tax information. So just a lot of things that are not available to the average person. The cost of genetic testing, again, if it's appropriate, we will cover. And the cost of our services to a party is either free or very, very, very small. And for most people, it's absolutely free. The only time we would charge is for parties where they have never been cash aided, and we will charge them $25 for the whole year if we've already collected $500 on their behalf. Okay, and then another main benefit of a CSSD case is that we have many more enforcement mechanisms at our disposal, including an income withholding order. So that's issued directly to the employer. We tell the employer, this is the court order, you take it out of their paychecks, they never even see the money. It's a way to guarantee that these child support payments are being made and on a consistent basis. We can also suspend driver's licenses, any kind of professional license, real estate, chiropractor, developers, law licenses, security license, basically any kind of license. We can issue bank levies, so take money out of bank accounts. We can put a hold on your passport, and we can intercept tax refunds, and we could put liens on, again, anything: property, workers' comp, personal injury, civil settlements, probate, retirement. Okay, so I know it sounds like we can do a lot. I feel like it makes us sound like we're more impressive than we are. But anyway, okay, so services not provided by CSSD. So again, we do not represent any parties. We will not provide genetic testing where parentage has already been established. So it's not like we're a place where anyone can just show up and say, well, I'm not sure, can you just give me a DNA test? It doesn't work that way. And our courts, again, as Brian mentioned, will not address custody or visitation issues. We will not establish or modify spousal support orders. And again, we won't enforce it once child support terminates. And given our volume of cases, so as Brian mentioned, we are a high volume court, just like Dependency is, and it does prevent us from doing extensive discovery of earnings or assets. So the best kind of cases that we can enforce in are obviously people who get paid through a regular paycheck, they get their W-2 wage employee, we can take the money out of their paychecks. But for people who get paid in cash under the table, who are self-employed and make up fake taxes, it's really difficult for us to expend the resources to do that kind of discovery. So in those cases, it's actually, it would be probably better for a custodial party to hire their own counsel. All right, passing it.
Okay, so Calmay talked about Britney Spears. Who wants to talk about R. Kelly? As you guys know, last month R. Kelly got in trouble again, and he was in prison for a jail for a short time. Got released, went back to jail for child support. This all took place in Cook County in Chicago, Illinois, and it related to his arrears balance of $161,633, which was owed in child support. Which was surprising when I looked it up, is that the court order was entered in January of 2009, and it was a monthly support obligation of $20,833. So in retrospect, I was surprised because that's actually not that big of an arrears balance for that high of an order. He was actually only in arrears maybe 5 months he didn't pay with interest, 5-6 months. But of course, it became an issue. He was held in contempt until someone made an anonymous payment to get him out. And yes, there are anonymous payments that are made for child support. For what we do, as I said, we can be considered a hybrid of the DA and county council. It's because we do contempt proceedings. At that time, a participant will be appointed a public defender because there is potential for jail time. But relating back to our presentation now, dependency and child support. So this section is aimed more for discussions that you might have with your clients. First, can the dependency court adjust child support? You probably never had to deal with it because the answer is no. Dependency courts, the juvenile courts, have no authority over child support. And that was addressed specifically in a 2007 case where the support was terminated by the dependency court because of a change in circumstance. And it was on appeal that they said that was improper. It would have to be determined by the family court or the Title 40 court. There's two issues that your clients will probably be dealing with if they have a current child support order and a dependency case kicks in. The first is the modification or change in child support. A change in child support, as Calmay previously stated, can happen at any time. The trigger isn't a time limit, it's a material change in circumstance, the key word being material. That usually is a finding of a guideline that's $50 or so different, at least $50 different than the current support amount. One thing to keep in mind though is just because there's a change doesn't allow the support. Unfortunately, we have to have these enforcement mechanisms because people behave badly. One is they're voluntarily underemployed or they divest themselves of their earning ability to avoid support. So the court obviously says that's not fair, it's impermissible as the trigger. This includes, surprisingly, people going to school. So it's hard to explain to a lot of younger parents who are in college but their support obligation is to their children, and it's right now. The children need food and shelter right now, not in the future, even if they're trying to better themselves. So we have parents coming in and say that, great, you got into law school. Unfortunately, you have to still pay support. Calmay makes fun of me because I call this the golden rule of child support. It's not necessarily the golden rule, but it is the biggest factor when we go to courts, and that is there is no retroactive modification of child support. So a support order can't be changed back in time until they've filed a motion and notice was given. So what we look for now, because of the federal regulations, is specifically when notice went out that someone's requesting a change. Either the county is requesting it or the participants. For example, if the notice went out in February, then any change in the support amount would be as of March 1st. So the support amount might be $1,000, it gets changed to $500. Again, it wouldn't be until the month after the notice was given of the hearing that that change would kick in. It's important to your clients to know because sometimes they wait on that. They might get custody or lose custody, and they might not file for 2 years. Unfortunately, that 2-year period, you don't get credit, or you don't get the change for. You would have to seek credits. And in child support, those are called Jackson credits. Again, Jackson credits focus only on the back pay. Modification will be the current support. Credits go toward your back pay balance. And that goes from the case Jackson versus Jackson. In Jackson, the court looked at essentially equitable relief for when a change in custody happens. But it was very case and fact specific. For example, in that case, the obligor, he assumed custody of the child with the consent of the previous custodial parent. So they agreed to have this. And the court also found that the obligor had met his support obligation by assuming custody. So he was paying for the child and meeting her basic necessities by doing that. So not every case is like Jackson. Just because there might be a dependency case and a change doesn't necessarily mean they will get credits for that. Possible reasons to deny credits, and the two most common being public cash aid being given to the participants. So if one parent is receiving welfare, they're still receiving that welfare. The courts found it's not equitable to the county, which is providing, or the taxpayers like us, which is providing for the family, to lose out on that reimbursement. Again, that gives the incentive to come in as soon as possible to modify child support. Disclaimer is this isn't always the case. The courts do have discretion in this. Again, this is just possible reasons why it might be denied for your clients. The other is, as I mentioned, there's no retroactive modification of child support. And just because there's a change in custody doesn't mean that a parent has lost total custody. In Jackson, the parent had lost total custody. It was sole custody back to the father. In a lot of cases, the other parent might have visits on the weekends. And the courts kind of tend to look at it as if they've retained some visitation, it's different than Jackson, and they might not get credit for that back period. The next few slides will address some questions I know I had when I was a ladle. Parents would ask me, some of my clients, I had no clue what to answer. The answer is very simple, and just to break it down, is always, you can refer them to the child support department, which you guys now have the information to, and or the family law facilitator for more immediate response. But the first question you might hear is, my child was detained from his mother and placed in my care. How do I stop paying support? Again, one, contact our department, and you can find that on the handout. Be sure though to mention to them that they need to provide the minute order, because a lot of times we have people coming from dependency courts with a detention report. And as we all know, that might not last through the detention hearing. So it's important that we get court orders. The minute orders are the most important because that shows where the child was actually placed by a court order. And I mentioned contacting the family law facilitator. As Calmay said, we have great services and we're happy to help, but with our caseloads, it takes time for them. So usually on average, we tell people 6 months before we can review it and get them in court. If they go to the family law facilitator, they can get a court hearing most likely within 30 to 60 days. So they should contact us, but it is better for them to talk to the family law facilitator. Importantly too, we're happy to help provide and reviews for modifications, but the county will not request credits. That's something they have to do. And that's something, again, they should probably talk to the facilitator about. We just don't handle credits. We handle modifications on our motions. The second question is, the children were detained from me and placed in foster care. Do I need to pay support? If there isn't a support obligation existing, if they don't have a child support order, Callie may touch upon this. We won't seek a support order unless family reunification has been terminated. Again, the objective is to reunify the families, and they don't want to put that burden on them during that time. But if the FR is terminated and there's foster care and money getting distributed to the foster care parent, then yes, they might be obligated to pay that support. If there's a current support order, again, that would go to the first answer. You need to modify it. So contact us and or the family law facilitator. A third question is the opposite of one we've talked about, is if the children were detained from the mother and placed in my care, how do I receive support? If support wasn't in play before, they certainly can contact us and apply for services. If not, then, if it's been established and they're paying support, then they can contact us. An important caveat for this one is, if there's a change in custody and now the new custodial parent wants support against the other parent, they need to request services from us. If they don't request services, they can get to court and the court can find that the other parent might owe them money, but it doesn't have jurisdiction because we're the Title 40 courts. So they need to get jurisdiction by applying for it. It's very kind of strange, but they need to apply for services if they want support. Lastly is if they're placed in relative placement with the grandparent. Again, if family reunification is still in play, we won't have a child support case. But if it's terminated, then they might owe money due to King Gap. Okay. Exit orders are an important aspect of this too. Obviously, it's best to get them out of dependency courts and get those exit orders. But be sure if a child support case isn't established and your client now wants support, make sure that they have the exit order with a paternity finding, because paternity issues are one of the first issues for child support as well. So have your client provide that exit order with the paternity finding, which my understanding they're attached to it. And if it's already been established, then they certainly can provide that exit order. I want to be clear though, and we mentioned this several times, exit orders might say joint, which we consider 50-50, and at least I used to tell my clients that's roughly 50-50. You have to go to family court to determine the actual percentages. And that's what we're looking for too. Just because parents provide us with joint custody orders, it doesn't mean that calculation will be 50-50. It will be what's actually happening. And if it's only 5%, we have to use only 5%. All right, and Calmay will touch upon paternity. Okay,
home stretch. Okay, so finally, we want to discuss parentage issues because it's a substantive area that differs in significant ways in practice between the court systems. It's also an area where participants and your clients could benefit if there were more communication between the two systems. So in general, in child support, CSSD will not establish or enforce a child support order without an underlying finding of parentage. That's pretty obvious. The most common bases are what you would see here: voluntary declarations of parentage, so POP-DECs, marriage, and by genetic testing. No practical distinction is made between types of father. So here, obviously, we have presumed, biological, alleged. Those are not categories that really exist outside of dependency. It's just really, are you the legal father, yes or no? Yes, we will. If yes, then we will enforce child support. And parentage is very rarely established under Family Code 7611D, and by very rarely, I mean I've never seen it. We would always seek to, in terms of looking for a parent to be responsible for a child, we're always looking for voluntary declarations of parentage or marriage, and if that doesn't exist, then we will offer genetic testing and try to establish it that way. We will not make an argument that, well, you've been acting as the father and therefore you should be held financially responsible for the child. So that's just not a thing that happens in our courts. And the most common type of parentage litigation that we engage in is actually kind of specific. It's where parents are seeking genetic testing despite having signed a voluntary declaration of parentage. So under Family Code 7573, a POP declaration has the same force and effect as a judgment of paternity issued by a court of competent jurisdiction. So if we see a POP, that's it for us. That's all we need to know. This declaration, because it's a judgment already, we're not going to offer genetic testing for someone who's already a legal father. That declaration needs to be set aside pursuant to Family Code 7575 before genetic testing will be provided. So this is what comes up the most often, is somebody comes around 10 years later saying, I want a genetic test, I wasn't sure about this child, but the 2-year window has closed, and so we will object to that pretty strongly. And another interesting difference is because of the different motivations at play, and this was very interesting to me, especially when I first came to child support, is that in dependency, everybody wants to be the father, right? Yes, I'm the presumed father. I want access, I want services, I want the most that you can provide me most of the time. Think about in child support. They come around and the question is who's going to be providing for the child? Oh, not me, I'm not sure. I haven't had genetics. So it is true that there actually are people who have been found presumed in dependency and will turn around and deny parentage when child support comes, when a child support action comes. And the law has recognized that the dependency court has more latitude when it comes to obviously finding fathers. And the stated emphasis in dependency is relationship over biology. We would just let you know, just note that if a dependency action results in multiple fathers, in practice, we will still only enforce child support against a pop father if one exists, or a biological father. Again, there are scenarios where somebody is a pop father, there's already a child support case, they're already paying, or at least they're obligated to pay, and then somebody else is found to be presumed, and so the presumed father gets custody and visitation and services, and you've got somebody else over here who's responsible for paying child support. That is a real problem, and we do not have an answer to that. Okay, so this is why cooperation between legal systems is so important, because these conflicting parentage findings can really create long-term problems for families once they, what was our favorite outcome in dependency? Like, oh, no more risk, go on your way. Any more issues, deal with it in family court. Well, now that I'm in family law court, I'm like, oh, well, there's a lot that needs to be worked out here. So actually, the California judiciary has actually already contemplated this issue, and there are rules in place for communication. So the California Rule of Court 5.635, it says generally that the juvenile court has a responsibility for establishing parentage. But here, Rule of Court 5.635 D2, the court must actually direct the court to prepare and transmit this form, the JV 500, to the local child support agency and inquire whether parentage has already been established through any other superior court order or judgment through the so you're supposed to ask, and I know that doesn't happen. And then, Rule of Court 5.635 D3, we are actually supposed to respond within 25 days and provide certified copies of any prior orders or any POPs, and that doesn't happen either. And the dependency court is supposed to take judicial notice of any prior determination of parentage. It's not bound necessarily, but it is supposed to take judicial notice. So just something as a practice point, it would be great as parents counsel to just ask, is there a child support case open? Has there ever been one open? Because if there is a child support case open, it means there's already been a parentage finding somewhere against someone, or finding someone. Okay? So once a parentage finding has been made, the dependency court is supposed to advise the parent that if the child receives welfare payments, the parent may be subject to an action to obtain support payments. I kind of recall maybe some bench officers saying this briefly when they go over the JV 505, but I don't think that it's stressed, and I do remember that I didn't try to stress it because I didn't want to scare people from taking responsibility necessarily, but after the findings are made, the court is also supposed to notify child support that the parentage finding has been made. I do recall doing the JV 501, but just so you know, it does not go to child support. We don't see that form at all. So, okay. And finally, related to this issue of communication, there are supposed to be carve-outs for confidentiality. So obviously dependency records are supposed to be confidential, and in order to have access, one would have to file a motion under Welfare and Institutions Code 827, okay? But there are carve-outs under WIC 827A1, California Rule of Court, and local rules that sets forth entities that should be able to inspect a juvenile case without a court order, and under this rule, that includes a local child support agency for the purpose of establishing paternity. And finally, there's even a form to do this. So there is a local form at JUV010, and I just put this in for your reference. It doesn't actually affect you guys that much. This is our own personal pet project. Okay, so this form actually has a place for, it's a form that exists so that a local child support agency should be able to easily access these records. And the intention behind that is so that we can avoid making these conflicting orders and making things more complicated for people who are already struggling to get through the system. But because everything kind of exists in these little silos, these are just issues that can come up just that we wanted you to be aware of. And Brian and I are actually on a project together to try to work with the other counties to increase this this cooperation. There's actually, because LA County is so big, this is our reality, but we have spoken to other bench officers who are like, well, if you had a problem, why don't you just go upstairs and talk to the dependency court, because they're all in one building, and that's just not our situation. But we wanted to put that out there into the universe for future change. And I think that's it for our presentation. Thank you so much. Okay, so we made pretty good time. So I think we'll open it to questions. Should I outline this? I'll ask everyone first. Go ahead. Are there any questions? Yes.
Well, okay. About domestic violence restraining orders.
Yes.
Okay, so if the court, a family court issues the restraining order and it could trigger a modification, is that triggered automatically, or does the client parent have to go seek a modification? Because it is a court order, but it's also, whose job is it to go change that?
It would be the parent. It would. There's nothing automatic. We're not informed of these orders. If the parents are not, same thing with dependency orders. If someone didn't bring the order to us, which is why we're asking for you to advise your clients about certain things that we need, because we, again, as I said, we have difficulty accessing those records. So if someone doesn't provide it to us, we just proceed ahead as best we can. So that's how duplicate orders happen, because we don't have any other information. So if a modification happens, as Brian said, in terms of having the quickest way to actually get a modification is for that party to go to the family law facilitator's office and file for a modification themselves. We will be present at court to assist them in running the calculation, and we will obviously help with enforcement afterwards. But for that first step, it's faster if they, do it themselves. Yes, go ahead.
Quick follow-up. So do you think, because it takes time for these modifications to happen, do you think it's worth it for a parent to do that right away if there's a restraining order, say at the detention hearing or juris, because then presumably the other parent's getting FR too, so then maybe the child support court wouldn't want to change it until FR is terminated. You know, so I'm just wondering about timing. Like, should they do it as soon as possible, or it doesn't really matter, honestly?
Well, let me clarify a couple of things. The FR issue is only if there isn't a case already open and if the foster care parent is receiving welfare. Okay, so if the foster care parent is receiving cash aid, then that's what kicks us all in. If not, yes, certainly the other parents, if no one's receiving welfare, they can request the modification on their own to get that support. In terms of the timing, it might take 30 to 60 days to actually have the court hearing. But again, the hinge is the date that notice goes out. So you can go to the family law facilitator and ask for a modification, and then if you serve it on us, we can serve it to the other parent the next day. And then that means if you go to court a month later, the support order still might change back in time. It won't change when the court hearing was, it'll change the month after that. So again, the time is of the essence to get that motion filed and served versus, that kind of helps. Now, I don't know if, there's a lot of going down the rabbit holes with some of these issues, and one is restraining orders, and I know it's very common for dependency to have restraining orders. That issue, I would say, is a little sensitive right now for us because we have had change in policy. And they went from enforcing child support restraining orders, that the child support's included in a restraining order, to saying, no, we're not going to enforce those orders. Because the county has...
Well, we're back in enforcement.
Exactly. So that's why it's hard. We didn't want to touch upon it too much, but that's why policies do change. And so unfortunately, sometimes you might want to be aware of that a client might come up to... one of your clients might come to us, ask for enforcement, and we have to say no, because there's just no means to enforce it.
And I would say, sorry, just about the modification. Again, the sooner you file it, you're reserving that date for a new order to possibly go back to that date. And also, if the circumstances change again by the time you get to the hearing date, you can take the motion off calendar. I don't think it hurts to actually file it during that interim period, but again, it's up to your client. Sorry, next question? Yes.
When you said that if the custody changes because the child's detained from the mom and placed in the dad's care and they need to provide a minute order, not the detention report, does it have to be a certified minute order, or will just a printout of a minute order suffice for your purposes?
I think a printout's fine. Again, that will be, there's twofold. There's one on our end, just trying to be transparent. We will look at the order. If there's no arrears balance, we might put a hold on any money coming in. We won't terminate the charging. We charge just like a bank or anything would charge. We would keep that running, but if he's still paying or she's still paying during that time, we'll keep it on hold, because if they get to court and the court changes it, then we can release it back to them. Now, if there's an arrears balance and they owe a bunch of back pay, it's not going to affect anything, so we'll keep collecting, and if it does change, it'll just be credited toward their back pay. And then there's something else I was going to mention on that point, and it totally slipped my mind now. But,
maybe I'll come back to you.
Yeah.
Any other questions? Yes, please.
Yes, just looking at page 18 here. Were you saying that even though this court directs the clerk to transmit the W501 to the child support agency, that never happens?
I'm pretty sure the clerk doesn't transmit it. That's what I'm saying. I think none of those processes are actually occurring, or those systems are actually occurring. Yeah.
and to go back, Jessica, the second part was about the being certified or not, the court order. For our purposes, it should be okay, but when they get to court, most of the time the courts, I would say most of the time, will accept it, but of course it becomes an evidentiary issue for the court whether it was certified. Because we've had times where parents still can, it comes up and they're saying one thing, there's a court order that's not certified, and then they start fighting about that. So.
Any other questions? Oh, shoot. Say it out loud for the Lancaster.
Will we hear the Lancaster people if they have questions? Or?
We were advised we were supposed to repeat the question for the Lancaster people, and we didn't do that. I'm so sorry. Are there any questions from Lancaster or San Diego?
Yeah, can you repeat everything you said? We didn't hear it because you didn't repeat the question.
Any other questions?
Anyway, I'm just kidding. Good presentation.
All right. Oh, sorry. Okay, I think that's it. Thank you so much for your time. So one instruction that we have.
My judge is going to kill me. I'll get that. Thank you.
Oh, yes, that's fine. That's a legal judgment.